right, welcome everyone. I'm going to call to order the meeting of the Minnesota Sentencing Guidelines Commission. Today is July 23rd, 2026, and I will ask our director to take the roll.
Roll call. Vice Chair Middlebrook.
Here.
Middlebrook present. Commissioner Castro. Commissioner Castro absent. Commissioner Eid. Commissioner Eid absent. Commissioner Fraze.
Here.
Commissioner Fraze present. Commissioner Keefe.
Here.
Commissioner Keefe present. Commissioner Ladd.
Here.
Commissioner Ladd present. Commissioner Mazzaros. Commissioner Mazzaros absent. Commissioner Moore.
Present.
Commissioner Moore present. Commissioner Moran. Commissioner Moran absent. Commissioner Mueller.
Present.
Commissioner Mueller present. Commissioner Reeves. Commissioner Reeves present. Commissioner Saxena. Commissioner Saxena absent. Chair Mitchell.
Here.
Chair Mitchell present. Madam Chair, there are 8 members present, 5 members absent.
Excellent. All right, next item on our agenda is it's approval of the agenda. Hang on one sec. Yeah, next one is adoption of the meeting agenda. I would entertain a motion to approve the agenda. So Commissioner Middlebrook moves that and Commissioner Reeves seconds. Any discussion on the agenda? Hearing none, we'll take that roll.
To the Middlebrook motion to adopt the agenda, Middlebrook.
Yes.
Middlebrook, yes. Castro. Castro absent. Eid. Eid absent. Fraze.
Yes.
Fraze, yes. Keefe.
Yes.
Keefe, yes. Ladd.
Yes.
Ladd, yes. Mazzaros. Mazzaros absent. Moore.
Yes.
Moore, yes. Moran. Moran absent. Mueller.
Yes.
Mueller, yes. Reeves. Reeves, yes. Saxena. Saxena absent. Chair Mitchell.
Yes.
Chair Mitchell, yes. One moment, please. Mr. Castro is having trouble logging him in. I'm just giving him some directions. Madam Chair, to the Middlebrook motion to adopt the agenda, there are 8 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Next item on the agenda is approval of the draft meeting minutes from June 4th. So this is our last meeting, not the public hearing. You should have all had an opportunity to review the minutes as they were sent out with materials last week. I would entertain a motion to approve the minutes.
So moved.
Commissioner Moore makes that motion. Do we have a second? Commissioner Reeves seconds. Any discussion on the minutes? Hearing none, we'll take the roll.
To the Moore motion to approve the June 4th, 2026 meeting minutes, Middlebrook?
Yes.
Middlebrook, yes. Castro? Castro absent. Eid? Eid absent. Fraze?
Yes.
Fraze, yes. Keefe?
Yes.
Keefe, yes. Ladd?
Yes.
Ladd, yes. Mazzaros? Mazzaros absent. Moore?
Yes.
Moore, yes. Moran? Moran absent. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena? Saxena absent. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
With that, the motion is approved unanimously. All right, we're going to move on to a review of the public hearing record. I just want to thank Vice Chair Middlebrook for presiding over the hearing last week when I was unable to be here. So let's hear how it went.
Madam Chair, on Monday, June 15th, 2026, the notice of public hearing was published in the State Register, Volume 50, Number 50, and the contents of the proposed modifications were posted on the Commission's website. The same day, an email notice of public hearing was sent to persons who have signed up on the Commission's website to receive informational emails. No one was notified by United States Mail because there are no longer members of the public on the United States mailing list. Pursuant to the public hearing notice, the public hearing was held on July 16th, 2026 in this room and by telephone and or electronically. I was the only person who wished to or did testify. After the public hearing, the record remained open for 5 calendar days through July 21st, 2026 to accept written comments. From the beginning of the public hearing notice period through the end of the public comment period, the Commission received 2 written comments regarding the subject of the public hearing. The complete public hearing record, including a list of those who spoke at the hearing, a link to the video and audio of the hearing, and copies of the written comments, was provided to all Commission members on July 22nd, 2026, yesterday, was posted in its entirety on the Commission's website shortly thereafter, and is included in today's meeting materials. Madam Chair, the Commission appears to have substantially complied with all public notice and hearing requirements to permit it to take final action on the proposed modifications today.
Great. Does anyone have any questions about the record for the public hearing before we move on? Okay, so next one is acceptance or rejection of the proposed amendments to the sentencing guidelines. Because we did receive 2 comments that are asking us to make changes to the recommendations that we had, I think we need to discuss those and determine whether we would make any changes based on those 2 comments. And if so, then I think we'll be able to do a package acceptance or approval with any of those changes if we choose to adopt them as well. So I think that's how we approach it. The first one is the change that our Director Wrights has proposed. Do you want to just real quick give us the 1-sentence reminder of what that is?
Yes, thank you, ma'am. Essentially, the main problem was that as we drafted it and as you approved it, so this is a staff error, it implied that the severity level is 7 ranking for theft from a vulnerable adult over 35,000 applied to thefts in general, but the way the legislature structured that, it only applies to specific types of theft, chiefly theft by deception and theft by swindle. And so we're just making that clarification. We don't want it to be incorrectly used more broadly than the statute provides for.
So you're basically adding all of the statutory references needed to hone in on the specific offenses that applies to.
Precisely so, Madam Chair. Yeah.
Okay. So that's the first one. And I guess why don't we just take that one? Because I think if there's agreement that we should make this change, I guess my question to you, Nate, is how do you want us to proceed with voting today? Do you want us to have a separate vote on whether we're going to make a change that's been requested and then do the whole package as amended? or would you rather us hold it all into one motion?
You know, I guess from my point of view, and I think there's many ways to do this, but it seems to me that the simplest thing to do would just have a vote on A, 1, 2, 3, 4, 5, and 7, as well as B in its entirety, since there were no public comments on those, and
Gotcha.
then take A6 and A8 separately.
Okay.
And see where people want to go with those.
Okay. So then we are working off of item number 4 is the proposed modifications. Okay, so say that again. So you're saying the ones we didn't have any discussion on were A,
Correct. So it would be essentially everything but A6 and A8.
okay,
So
so everything but A. So A, 1, 2, 3, 4, 5, and 7. And then B.
correct.
Okay, how about let's do it that way, folks. Let's talk about, I would entertain a motion to approve the proposed modifications in sections A, 1, 2, 3, 4, 5, and 7, and section B of our item number 4 proposed modifications document today.
So.
Commissioner Fraze makes that motion. Do we have a second?
Second.
Commissioner Reeves makes that second. Any discussion on the motion? Please do ask questions if things are unclear at this stage. Hearing none. Let's go ahead and take a vote on that.
I'm sorry. So who made the motion?
Commissioner
Fraze.
Fraze made the motion. Commissioner Reeves seconded.
Okay. So to the phrase motion to adopt parts A1, A2, A3, A4, A5, and A7, as well as part B entirely, as they were proposed and submitted to the public hearing on July 16th, 2026. Middlebrook?
Yes.
Middlebrook, yes. Castro? Let me just check my email here.
Still don't see him on there. No.
I don't either. Castro absent. Eid absent. Fraze.
Yes.
Fraze, yes. Keefe.
Yes.
Keefe, yes. Ladd.
Yes.
Ladd, yes. Mazaros. Mazaros absent. Moore.
Yes.
Moore, yes. Moran. Moran absent. Mueller.
Yes.
Mueller, yes. Reeves.
Yes.
Reeves, yes. Saxena. Saxena absent. Mitchell.
Yes.
Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
Right, with that, that motion, it passes unanimously. So now we can move to A6, which includes the enhanced penalties for theft from vulnerable adults. And we have the additional public comment from Director Wrights that proposes to change this a little bit as we just discussed so that we can really hone in on which offenses are actually impacted by this new sentencing enhancement. So the question would be, is there, given the input that we received from the director, is there a desire to adopt the alternative that was presented to us in the public hearing, or to stick with what we had originally? And I will let people move however they feel on this one. Commissioner Middlebrook.
I would move to adopt the proposal from the director. I think that those amendments really do clarify and correct what was somewhat overlooked on the initial proposal. So I would move to adopt that proposal.
Okay, great. We have a motion from Commissioner Middlebrook. Do we have a second? Second from Commissioner Fraze. Discussion on the motion? Hearing none, we'll go ahead and take a vote on that.
So to the Middlebrook motion to adopt item A6 as proposed and submitted to the public hearing on August 16th as modified by the July 9th, 2026 memo from myself.
Got it.
Middlebrook?
Yes.
Middlebrook, yes. Castro? Just check. Still don't see him. Castro, absent. Eid. Eid, absent. Phrase.
Yes.
Phrase, yes. Keefe.
Yes.
Keefe, yes. Ladd.
Yes.
Ladd, yes. Mazaros. Mazaros, absent. Moore.
Yes.
Moore, yes. Moran. Moran, absent. Mueller.
Yes.
Mueller, yes. Reeves.
I'll say it again.
Reeves. Reeves, no answer. Saxena. Saxena, absent. Mitchell.
Yes.
Mitchell, yes. Circling back to Commissioner Reeves, Commissioner Reeves, can you hear us? Reeves, no response. Madam Chair, there are 7 votes in favor, no votes opposed.
With that, the motion passes. Okay, so then the only item from the proposed modifications that is left is item A8, the rankings for new medical assistance fraud. And we've had a public comment from Attorney General Ellison requesting that the medical assistance fraud over 1 million, which we had proposed to be ranked at severity level 7, be ranked at severity level 8. So the question is there a desire to change that ranking or to go with what we originally proposed? Commissioner Fraze.
I guess I have 2 questions. The issue, can we just, for all of our benefits, have a summary of what the provision is of Medicaid fraud that we're talking about? And I guess related to that, what's the offense below that in that series of offenses? And the other question is, well, someone will raise this today, I guess. Why we put it at 7? I assume it's because it's not a crime of violence or high risk of violence. I assume that was our reason, but anyway, those are my questions.
Are you able to answer the
Yeah,
offense question?
I think so. So this is, we discussed this even when it was just a bill because there were some unusual thresholds here. There's the typical thresholds are basically 0. Sometimes there's $1,000 threshold, and then you get up to a $5,000 threshold, then a $35,000 threshold, and that's kind of the normal theft thresholds. And in talking with the representatives from the Attorney General's office, it was our understanding that the intent on the $100,000 threshold was really just to sort of update the $35,000 threshold, if you will. So that offense is proposed to be ranked essentially, or the commission's essentially proposing to rank that second highest threshold at severity level 5, which is honestly, I think it would help to peek ahead at some of the meeting materials that we're going to be looking at later in the meeting, which is the staff theft ranking exercise. See.
I mean, one thing I do want to say is that it was our understanding that the amounts that were included in the bill, so it's medical assistance fraud, so it's really the whole, the kind of thing we've seen in the news where somebody is making fraudulent claims for medical care that never occurred. But one of the it was our understanding that the amounts that were put into the bill were updating for inflation, right? Like the amounts that might be in the regular theft statutes were set a while ago and are at a certain number. But today they're taking them higher because what was $35,000, however many years ago, is now worth 100,000, essentially equivalent to 100,000. So some of these amounts were brought into today's dollars, but the $1 million crime is a new level that didn't exist before. I think that we were looking at theft as theft when we proposed the initial ranking. I think we were trying to be consistent with the fact that this would be more serious than the existing crimes that we had on the books. But as you said, theft is not a violent offense, and so keeping it in line with that. But that said, I don't have strong feelings about where this gets ranked ultimately. So
The crimes that were in the news were, or the one that's most notorious was well over 1 million, right?
yes, correct.
So the normal theft rankings are under 5,000 severity level 2, over 5,000 severity level 3. And then over 35,000, I can't say the guidelines are entirely consistent on this, but I would say that the modal answer there is severity level 6. So that kind of takes care of the first 3 rankings. If you think of 100,000 as the new 35,000, basically. But the new $1 million threshold is, new territory. I think it's reasonable to rank that at severity level 7 or severity level 8, I suppose. I will say that there's not a lot of property crimes that are above the disposition line. Identity theft, which the commission's actually looking at later today, is above the dispositional line. It's ranked at severity level 8 if it's over 35,000 or there are more than 8 victims. And then there are some other crimes, certain types of arson and burglary that I think kind of depart from the person offenses based on some of the elements that are involved in those crimes that depart from property. I think it's questionable whether those crimes are pure property crimes when you start getting some of the additional elements involved. I don't think of first degree aggravated robbery as a property crime. Some of the types of first degree burglary that are above the disposition line are arguably not property crimes. So, I think it's an important question to ask whether a property crime should be ranked above the disposition line, by which I mean that the first time somebody commits a felony is this crime. Nevertheless, they should still go to prison. That would be an unusual thing for the commission to say, but this is also an unusual threshold in that it's over $1 million. It's the first 7-digit threshold that we've seen.
Commissioner Moore.
Madam Chair, a question for Director Wrights. The Attorney General contrasts the crime that we just ranked, the theft of a vulnerable adult over $35,000, and points out that putting that at a level 7, the Attorney General asks us to consider the legislature's distinction in penalties to rank this at a level 8, and obviously we don't have anything comparable to $1 million max. Well, we do have $1 million fine, but the type of crime here is really extraordinary. Is that a rational distinction between a level 7 and a level 8? Understanding the validity of what you just said, that normally we don't have property crimes that are presumptive commits, at a true 0.
So if I would classify the rationality of ranking that essentially one severity level higher is it's a form of aggravated theft, essentially, similar to financial exploitation of a vulnerable adult, similar to, some of the other things that we'll be talking about later today. But normally the over $35,000 threshold would, again, not entirely consistently, but normally that would be ranked in severity level 6. but because the victim is a vulnerable adult, it makes it more, just more aggravated, I guess, for lack of a better word. So, so the commission ranks that, I would say, is at severity level 7, which is consistent with financial exploitation of a vulnerable adult. Also an aggravated theft circumstance because of the particular vulnerability of that victim. So, you know, do you have something like that in Medicaid fraud? I don't think so. I don't think there's anything particularly vulnerable about the government. But, or, you know, at least that's not how it's been. It's not how the commission has thought of it in the past. But as you point out, there's, as the Attorney General points out, there's a very high dollar amount here. So you could think of this differently if you wanted to, or you could just say, well, it's more serious than the previous level, so we'll increase it by 1 severity level.
If I could follow up with one more question, the Attorney General notes that the maximum penalty for this offense exceeds the maximum penalty for every offense ranked at a severity level 7 and for nearly every offense ranked at a severity level 8. And I haven't done my own independent research on that, but it seems like that's not an unreasonable thing given the extremely high fine here. You know, I don't know historically what the commission has taken from the legislature's decision to create a new crime that has a maximum penalty that is really different from any other maximum penalty in that kind of classification of crimes. If we're looking at this as a property offense, but it is pretty extraordinary. Hard to believe there'll be a lot of cases in this category, but as we've seen, there certainly have been some.
Unfortunately, Commissioner Eid was unable to be here, and he might have an answer to that. Madam Chair, there's a new phone caller on under the attendees, and before we get to Chief Mueller's question, I wonder if I could just unmute that caller and see if it's a commission member.
Go ahead.
All right. So for the attendees who are listening, there's a caller with a 651 area code. I'm going to unmute you just to see if you're the commission member for just a moment. All right, I'm unmuting the caller. Is this by chance Judge Castro?
It is. This is Judge Castro.
Okay. Thank you, Judge Castro. You're now in the meeting.
Thank you.
Did you put him? I don't think you did elevate him, did you?
I didn't elevate him because he's on the phone,
Oh,
but
and you
he can
can't.
still hear us. So
Okay,
it's
got it.
as good as being a panelist as far as the open meeting law is concerned.
Okay, gotcha. Thank you. Commissioner Mueller.
Yeah, thank you. I'd like to state that I am in favor of moving it up based on what the Attorney General presented. I think it is clearly a new threshold. Clearly, most thefts don't reach this level. I think there's an organized crime piece to this as well that I think we should take into consideration. To me, this doesn't fit under like our normal, using air quotes, thefts that we're addressing. And so based on those, I'm in favor of moving it up.
Thanks for that comment. Commissioner Leck.
Thank you. I too am in favor of the recommendation outlined in Attorney General Ellison's letter. I would note, and I think I will take a little issue with sort of the impact here, because while the government, it's dollars that come to the government through Medicaid, the people that they're serving are typically people who are vulnerable and need those resources. And when those resources are diverted for fraudulent means, it robs those people, and those people are typically in a vulnerable category. And it's not just one, it's multiple people. And I think that's why the offense is so egregious in terms of coordination, the scheming, and the diverting of those dollars. And I think given the threshold amount and also the maximum penalty, I think it's a clear signal from the legislature that this is not an insignificant crime, call it property or not, but I do think that it affects real people. And for those reasons, I would be in support of the recommendations outlined in Attorney General Ellison's letter.
Commissioner Fraze.
Well, I'm a bit ambivalent about this because I think in general, we need to be cautious about making policy based on, it's sometimes called the crime of the week. You know, one really bad case. This has happened all around the country over and over again. But, you know, in this case, I mean, first of all, I guess back to my original point that there are crimes already in level 8 that involve little, if any, actual or significant risk of physical harm. And then in terms of the impact, I guess besides what Commissioner Ladd just said, we see in a case like this that, and maybe it's just the current administration in Washington, but when you have fraud on this scale in a welfare program, it tends to discredit the program. So that hurts the victims, the recipients even more. And I guess finally, just the legislature, I mean, we have to make an independent judgment, but the legislature has certainly signaled with its fine and prison maxes that it considers this very serious. And I guess I would finally add, I hope it's not inappropriate, that I trust the judgment of the Attorney General on policy issues like this. I think he is a minister of justice, not just an advocate for one side. And if he thinks that this should be level 8, obviously we have to make an independent judgment, but I consider that weighty.
All right, so what we're looking for is a motion for something. So who would like to make a motion on this one? Oh, there's Commissioner Castro. Welcome to the meeting.
Me,
Took a while.
Okay,
Oh, now it's going.
now I gotta mute your phone, so there we go.
All right, does anyone want to make a motion on what we want to do with this item? So we either are moving to adopt the original rankings as proposed, or we are moving to adopt the rankings with the change that the most serious offense will be ranked at level 8 instead of level 7.
I would move to adopt the rankings as outlined in the Attorney General Ellison's letter, which would make this most serious ranking at a most serious offense at the level 8 and not severity level 7.
Right, do we have a second?
I second that motion.
That Commissioner Reeves seconds. Any discussion on the motion?
I have one question.
Commissioner Middlebrook.
I do have a question about, because this is gonna push it over the presumptive commit line, do we have any idea on the prison bed impact?
We, yeah, we did look at that. It was, I want to say a couple of cases, Jill, in the last decade that were 2 cases that would have been over the $1 million threshold, or were they were just under the million at that time. So we didn't see any $1 million cases. We saw 2 that would have been in the between 100,000 and $1 million. Having said that, were we looking at RICO cases? Do you know? Would we have seen a RICO case? So we might have missed some RICO cases, racketeering cases, and of course we wouldn't have seen any federal cases. We wouldn't have estimated an impact based on the data we had, but you know, it's possible that could change because maybe the state would have taken some cases that otherwise would have gone federal, or yeah, maybe they wouldn't have charged them on as RICO cases. I don't know.
That answered your question.
Yeah.
Okay.
And I believe that was a 10-year look back, if I'm recalling correctly. So
some of those amounts, again, might have been higher in today's dollars, but it sounds like we're talking about potentially a handful of cases.
that's a good point. I think one of those was getting pretty close to the $1 million mark, and it might have. Yeah, so it's possible that you know, I don't recall when that was done, but it's possible with inflation, that would have been $1 million case today.
Mhm. Yeah. Okay. Any other discussion or questions? Okay, hearing none, we'll take a vote on that.
All right, to the lad, motion to adopt A8 as proposed and submitted to the public hearing on August 16th with the revision of severity level 8 rather than severity level 7 offense for the top tier as recommended by the Attorney General in his letter dated July 15th, 2026. Middlebrook?
No.
Middlebrook, no. Castro?
Yes.
Castro, yes. Ede? Ede, absent. Phrase?
Yes.
Phrase, yes. Keefe?
Yes.
Keefe, yes. Ladd?
Yes.
Ladd, yes. Mazzaros? Mazzaros, absent. Moore?
Yes.
Moore, yes. Moran? Moran, absent. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena? Saxena, absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, 1 vote opposed.
And with that, the motion is approved. And I believe that covers all of the proposed amendments, correct?
It does, Madam Chair. So the August 1st is a Saturday. So on Friday, we will be publishing the 2026 edition of the sentencing guidelines, Friday next week.
Great, thank you. Okay, we're gonna move on to agenda item number 6, which is comprehensive review ranking project. And we had this actually on our last meeting. Yeah, Commissioner, just
Before you get there, just a question, the technical amendments, did we vote on those too? They're
yeah,
all-
we did that
Okay.
for the first one.
Okay.
Okay, there wasn't anything in there that you wanted, okay, good. All right, comprehensive ranking project, we had this on our last agenda. But we didn't have time. There's a lot going on with all the work that we were doing to get through the end of the year. So staff are here to help walk us through the results of the packets that we worked on a couple of weeks ago. I will turn it over to them when they're ready.
All right. I'm gonna turn it over to Research Supervisor Leah Powell.
All right, we are loading the presentation. All right. So we are gonna have a discussion on the ranking feedback that we received from you on the aggravated and motor vehicle theft offenses. If you remember, and again, this was a couple months ago, this offense packet was divided up into 2 different chapters. The first chapter included theft offenses ranked at a more severe severity level because of high monetary threshold or due to certain offense characteristics. And chapter 2 focused on theft, receiving stolen property offenses that involve a motor vehicle. You all completed your packets and returned them to us on May 18th. And then we compiled all the information. I do want to remind you that this ranking exercise was a little bit different than all the other ranking exercises you did. Previously, you were asked to look at each individual offense and consider a re-ranking decision. This exercise really focused more on the grouping of offenses and whether or not there was a need to re-rank to make them more consistent. So hopefully this makes sense. We'll walk you through it. And I'm encouraging discussion here, but I'm going to start with the aggravated theft offenses. And this relates a lot to the conversation you just had about the last agenda item. The offenses in this group, there are 4 of them: identity theft, financial exploitation of a vulnerable adult, theft with foreseeable risk of bodily harm, and organized retail theft. And each of these offenses have a variety of severity levels, and those are based on dollar amounts. So if we go to the next slide, you can see where these are on the grid. And just
to give you an example for the identity theft offenses, you'll see the $35,000 or more is currently ranked at 8. 2,500 to 35,000 is currently ranked at 3, and $501 to 2,500 is currently ranked at a 2. And then you see the other groups of offenses, and you'll see that there are inconsistencies in some of the dollar amounts and rankings. So that was kind of the focus of this group and re-ranking. So, question was asked, what re-ranking option do you feel is appropriate for these 16 aggravated theft offenses? And 3 responses were no rank, let's keep them as is. And then we got 7 responses that there should be some re-ranking with the goal to try to make at least some of the offenses more consistent. So then the follow-up was, okay, looking at each of these by the dollar amounts and the consistency within the dollar amounts. So the first grouping we're looking at here are the 35,000 or more offenses, and there were 2 of them. There was the ID theft, which is currently ranked at 8, and then the financial exploitation of a vulnerable adult, which is currently ranked at 7. So there were, let's see, 6 responses to re-rank this group of offenses to make them consistent. So that's what this slide is showing, is those kind of recommendations to make them more consistent. There was 1 response to say, let's re-rank these 2 at severity level 6. There were 3 responses to re-rank both of these offenses at a 7. And then there were 2 responses to re-rank both of these offenses at severity level 8. Hopefully that makes some sense. I would ask, are there any questions or any comments or discussion around these 2 offenses and the rankings?
I'm just gonna comment, because it is interesting that we're having this discussion today after the discussion that we just had, because it makes me wonder why we ranked identity theft at severity level 8 when we did. And I don't exactly know how to articulate like what I'm wondering about, but I think I even did raise this with my responses, which I'm not in this group, but you know, I know that identity theft can be really, really quite damaging to an individual, especially in the technology era that we're in. So you know, it's possible that that's what we were thinking about when that offense was originally ranked. But I'm not really sure what these cases look like. And I don't know if there's anyone on the commission who does have a sense of like when that ends up getting charged here. Because that would really help me understand like where an appropriate ranking might be.
Sure.
Yeah, Director Wright.
Just to bring to your reminder that this is from, I think, the May meeting materials. There is a note in there about the severity level 8 ranking, and the commissioners, and this is looking at the 2003 minutes when this decision was made. The commission's rationale is, as reflected in the minutes, appeared to focus on 2 things. One is the intangible harm to the victim's credit exceeding the dollars lost. And second, the similarity of the offense's elements to the one of the aggravating factors in the sentencing guidelines, the major economic offense aggravating factor.
Anybody else have comments or questions on this one? Commissioner Noble?
Thank you, Madam Chair. One thing that I think is, since way back then, in 2003, I mean, you've seen like the fact pattern can really be very, you know, there's a huge variation on the fact pattern, and a lot of times it's charged out and the person is convicted where there isn't even a loss to the victims. But there is that penalty that for every single one, it's $1,000 that they have to pay in restitution, whether or not there's any loss or not. And it just seems that it's been a really high departure rate, particularly a dispositional departure rate on this, that it does seem, in my opinion, that it is overranked. It really probably fits better with the severity level 7. And if you compare it to the exploitation of a vulnerable adult, it seems that it really shouldn't be higher, ranked higher from just the culpability standpoint. And then if we're gonna do the over $1 million at severity level 8, then it seems like it really is a little bit out of whack, yeah.
Commissioner Moore.
Well, in my experience, mostly as a district court judge, the people that came into my courtroom that were victims of identity theft, it goes oftentimes well beyond just the dollars and cents. I mean, oftentimes there were circumstances where people's social security card numbers or their driver's license cards have been used for employment or other purposes, and we would get people that were victims that were out of state oftentimes that would be calling in and talking about sort of the cascading full of identity theft on them as an individual. And I think that what goes to some of the comments that Director Rice was talking about earlier, that it is hard, I think, in these cases to always quantify exactly the harm. Obviously, there's intangible harm that would be required, or tangible harm, to get to a $35,000 or more threshold. But there is something uniquely personal and demoralizing and traumatizing about having your identity taken by somebody else and used for whatever purposes they're using it for, whether it's medical, whether it's for other, employment related or driver's license purposes or something like that. It can be a real labyrinth to get that all untangled out of the bureaucracy, and take a lot of time and difficulty. And I don't know how many of these cases, Director Rice, do we have any data on how many of these over $35,000 identity theft cases we were seeing in the district courts?
Looking at the data that gave you back in May, it's a long time ago. Maybe I could pull it up here. Well, you've got it. To the presenter right now.
Would you like me to pull it up?
Looks like there were 333
Yeah.
cases. That one?
Yeah.
Find what?
That's 10-year time period.
Over a 10-year time period. Yeah, okay. So there's,
What was the number? I'm sorry.
it's 2015 to 2024. 333 cases total. 187 received, or so 56% received a dispositional departure. 146 received actual prison.
I mean, Commissioner Middlebrooke makes a reasonable point regarding the $1 million crime that we just ranked, or voted to rank at a severity level 8. Consistency should be a goal here in terms of our actions. I guess but I'm a little more distant from the district court than some others on this call. If there's been, more recent examples of these identity theft cases in this range, maybe that'd be more helpful to the commission.
It looks like quantity wise, there's pretty evenly among the 3 felony severity levels. 26 cases a year at the severity level 2, 36 a year at the severity level 3, and 33 a year at severity level 8, and a remarkably high dispositional departure rate, and a guidelines true 0 at 84%.
Okay, here's what I'm
Dispositional for-
confused about, though. Here's what I'm confused about. When I'm looking at the statute, there are intervening levels. So the way that this is structured is, it's identity theft, but then the penalty is structured based on the number of victims and how much money was lost. And there's actually like 5 levels there, but we only have 3 of them. So does that mean that the intervening ones weren't charged?
So.
So it's because it's subdivision, it's the penalty, looking at the penalty. Subdivision 3(1) is a single victim and the total value is $250 or less. Subdivision 2 is,
That's a misdemeanor.
oh, sorry, those are misdemeanors. Okay,
Yeah,
gotcha.
misdemeanor.
Gotcha.
Yeah, misdemeanor, gross
Gotcha.
misdemeanor, first 2. Yeah.
Okay, this explains the problem.
Yep.
So you've got, okay, misdemeanor, gross misdemeanor, there we go. Then the felony start at subdivision at paragraph 3. It's a 2 up there. That's another thing I'm confused about. So, I think like looking at this, I don't know, personally looking at this, I think it's inconsistent to put it at severity level 8 because so the first one there is 2 or 3 direct victims. Between the damage is 500 to 2,500. The next one is 3, but not more than 7. Damage is 2,500. Next one is 8 or more, and the damage is more than 35,000. So it's not a very well written statute. I mean, it just doesn't. The harm isn't necessarily the amount, and that's what's, it feels off. Anyway, sorry, Commissioner Middlebrook, and then Commissioner Ladd, did you have your hand up too? Okay, so Middlebrook and Ladd.
Thank you, Madam Chair. Just one other point is that looking at this one where the loss is over 35,000, the legislature put a 20-year stat max, the same as the exploitation of a vulnerable adult, where it's over 35,000. It seems that those are, something a little more comparable to.
20-year versus 30-year. You okay?
Yes, I am, sorry.
Okay, no.
I'm allergic to something in here, I guess.
Okay.
Can I go?
Yes.
I just wanted to say, I think, as an aside, and I think to talk about a little bit with departures with crimes like this, that one of the main prevailing things that we hear a lot in the district court in these cases when we're navigating them and resolving them and why departures are granted is the victims want their money. And if people are in prison, they can't pay. So that is a really heavy factor when those cases are getting resolved in terms of giving somebody the opportunity to make the victims whole. And then the idea that prison's kind of hanging out over here is sort of the consequence that maybe they otherwise should have gotten, but with the hope that they do this over here. I'm not saying that that's the case always, but I do think that that weighs heavily in terms of why departures are happening on those property crimes when there's restitution. Because the idea is to make the victims whole, and part of making them whole is that getting the money back. And if they're sitting in prison, that's not happening. So again, not to not address the dispositional issue, but I think that that's the competing factor there in terms of the consequence at the end of a sentence regarding incarceration and other things that come with it or not, or probation and not. I do think that is an explanation as to why departures are probably seen higher in those kind of crimes than other kind of crimes.
Yeah, I think what I'm trying to raise is a proportionality issue, because it is the same behavior all the way through, but now it's one more person. And it goes from severity level 3 to 8 for that one more person. And that feels very disproportionate to me. 3 to 7 would also be a big jump, but I can get behind it more because it's 8 or more. So it could be more than 8, right? And so I think we should be considering reducing the ranking to 7 on this one. Commissioner Reese.
I think that was my vote and it is my vote to lower it to 7. It's a big jump. And I guess some of the people at 7 will be over the line. There may still be departures there to let them pay. But yeah, it just seems like one victim, no more than one victim, it could be more than 8. Big jump from over 2,500 to over 35,000. Yeah, I guess so. Let's see, we were comparing this to financial exploitation of a vulnerable adult. Yeah, I don't know. There's something I'd have to know more about kind of the typical paradigm scenarios and for that, but I'm guessing a lot of it involves an abuse, a violation of trust. And that is more culpable than just pure greed and stealing somebody's identity. So anyway, I'm in favor of lowering it to 7.
Well, I don't think today is a voting day, so I think we could bring this one back for, I know we're also a little light on commission members, so why don't we bring this one back for, like in the September meeting zone, for consideration as to whether or not we should re-rank that one. Please keep
Are we
going.
ready to move on? All right, we have a couple more groupings to go. Let's see how we feel about these. All right. Now we're going to look at the grouping of offenses that are over 5,000 but under 35,000. And we have 4 offenses that fall into this category: ID theft, which is ranked at a 3, the financial exploitation of a vulnerable adult, which is at a 5. Theft with foreseeable risk of bodily harm, ranked at a 4, and then organized retail theft, ranked at a 4. So there were, let's see, 6 recommendations here to re-rank to try to make them more consistent. 2 recommendations for re-ranking all of them at severity level 3. 2 recommendations to rank all of them at severity level 4. Then we had 1 recommendation each to rank them all at severity level 5, and then 1 for severity level 6. So again, discussion, comments, feedback.
So can somebody tell me, I really didn't understand what, the harm financial, what's the one that has to do with harm?
Theft with foreseeable risk
Yeah,
of bodily harm.
Theft with foreseeable risk of bodily harm. Can the prosecutor please tell me what that is? No?
There was a question, what act scenario was this?
I mean, the answer is probably not, because it doesn't occur very often. There's like 2 cases a year.
Okay.
And they were not in Wadena County.
I read the statute, I was like trying to be a good steward of our work here, and I could not understand like what facts this would encompass. Okay, well, that's just my again, I'm glad I'm not the only one, actually. Other discussion or comments on this one? Not hearing any, so probably can move on.
All right. So the next group we're going to talk about are the offenses that are $5,000 or less. And there are, again, 4 offenses here. The ID theft currently at severity level 2. The financial exploitation of a vulnerable adult currently at level 4. The theft with foreseeable risk of bodily harm at level 3. and the organized retail theft at severity level 3. So for this grouping of offenses, there were 5 recommendations to rank to make more consistent. 2 of those were to re-rank them all at severity level 2, and 3 were to re-rank all at severity level 4.
Severity level 3 is the winner? Is that? So I'm
Is it
getting
in the
from that.
middle?
I don't know.
Yeah, these are hard. I will say that for me, the real place that I'm personally looking at proportionality is between the top 2, the identity theft and felony, something of a vulnerable adult.
Financial
Financial explanation of a vulnerable adult. Because the other 2 offenses are either never charged or very rarely charged. And so because the top 2 have more, just more frequency, that's where I'm like really looking at, personally, that's where I'm really looking at proportionality. And for me, the vulnerability of the individual justifies some of those rankings being higher than for the identity theft offenses. In the different dollars amounts, there's like a couple of different factors there that are very hard to weigh against each other, but
I mean, I'll just say organized retail theft, I guess it's possible that it's occurring, but we haven't got the data yet because it's such a new offense.
yeah.
I actually was gonna check,
Yeah.
district court, see if they've got any data that would suggest that it's happening.
And then I don't know what the theft with harm is. So that's just a little window into how I'm thinking about these, but you all may be thinking about them differently.
What's really, Commissioner Middlebrook, Manager, what's really hard on these is that between the stat max and the amounts, not that they're so inconsistent, but there's not really anything we can do about that.
That's true.
You look at all of these, they're just, everyone's a little bit different.
Yeah. That's the other thing that makes it very hard. Commissioner Ladd.
So just to sort of follow up on that, is it appropriate or not as part of the comprehensive review that we would highlight that as a task to the legislature to say, hey, we're going through this. Here are some things in this sort of category classes of offenses. And these things presented some challenges to provide some consistency within the guidelines and lay out sort of what those are. And they will either say thank you and do something about it or say thank you and do nothing about it. But I think to Commissioner Middlebrook's point, I think that is the struggle, is that we're trying to take these offenses as what the elements are of them, what the stat maxes are for them, and then trying to say, let's try to group these together when they don't start from a similar starting point, other than kind of like crimes, but beyond that, they sort of diverge. So is it appropriate for us as a commission to sort of highlight that as part of this review process back to the legislature to say, we've identified these things, if you want to take a look at them or not, it would be helpful. I don't know. Is that something that we do or not do?
We definitely can.
Okay. I think that would be a helpful thing for us to maybe suggest.
Because it does, I mean, it is like, even the dollar amounts are weird, right? The dollar amounts are weird, the stat maxes are weird. And then you add in these other types of elements on top of that, of identity theft, exploitation of a vulnerable adult, so vulnerability of the victim. There's so many different things there that even it's hard to like figure out rationally how they stack up against each other.
Well, even the dollar, if I might,
Yeah.
Chair Mitchell, even to Director Rice's comments that has kind of said as a theme throughout, sort of the inflationary value of what $35,000 looks like today versus what it looked like 10 years ago or 15 years ago. And again, I think when we were talking about our last discussion, when you talk about, you know, a fraud case involving $1 million and the threshold is between 35,000 or 100,000 and it jumps to $1 million. There's a lot of real estate between those 2 points. And again, I just think the idea that the value of the thresholds plays into that in terms of, does that represent today's economic loss? I don't know if that's the right word or not, or the economic impact to the assessment of those crimes. And again, I think that that's a valid question too. And again, we're struggling with sort of comparing those values at what does that mean? So I think it would be a helpful thing to sort of put out there for them to take a look at and see if they're willing to give further guidance on that.
Commissioner Castro?
Yeah, thank you, Madam Chair. I'm not exactly sure what we're asking them to do, though. I mean, we can live under the idea that these were rationally put together when they, you know, selected an amount and a maximum penalty. But you know, given that they're all put together at different times and by different legislatures, I'm not so sure that there's a particular rhyme or reason. But so I guess my question is, what are we asking the legislature to guide us on? Whether or not we should be focusing on statutory maximums, or should we be focusing on the offense amount, or on both, or on neither?
I'm hearing, I mean, I thank you, Judge Castro. I 100% agree with you that some of the differences that we see arise because they are passed in different legislative sessions, and ideas about things change at different sessions, or they're not looking at everything together. But what we've had the benefit of doing is actually looking at them together. And so I think when you do that, then the stat maxes and the dollar amounts maybe don't go together very well when maybe they should. I think that's our question, is like, do you know, we perceive the stat max to indicate level of seriousness, and some of these offenses look similar to us in terms of level of seriousness, but you're giving us a different signal. So what's your intent there? You know, and the dollar amounts also typically communicate level of seriousness to us, but they are kind of all over the board. So it would be good if they could maybe take a look at these together and see how they would stack them up. I don't know. Commissioner Castro.
Thank you. I just, at some level, I'm just thinking to myself, be careful what you wish for. Because
Yeah.
if a policy decision is made by the legislature that we should be focusing on statutory maximums, for example, then that would play across all, you know, the severity levels of all the offenses. So just something to think about.
Well, and I don't think we'd be asking them, should we be focusing on this? What we'd be asking them is, do you want the stat maxes to be more similar?
I'm just saying what we asked them, and the answer they give us may be two different things.
Yeah, that's true. All right, any other discussion or comments on this one?
Madam Chair, it looks like there were 6 convictions for organized retail theft in 2025.
Oh, yeah. All right, I think we can go on to the next one.
All right, last grouping for this chapter at least. So we have two offenses in the enhanced misdemeanor or gross misdemeanor category here, and they are, it's a theft with foreseeable risk of bodily harm, which is currently ranked at severity level 2, and an organized retail theft currently ranked at severity level 1. And here there were 4 recommendations to try to make these two offenses more consistent. 1 recommendation to re-rank them both at severity level 1, 2 recommendations to re-rank both at severity level 2, and then 1 recommendation to re-rank both at severity level 4. Any comments or thoughts or feelings here?
I'm not hearing any.
Do we move on to the next chapter of offenses?
Yes, we can. Yeah.
All right, terrific. I've got the easy job of talking about chapter 2. It's much more straightforward. These are thefts involving a motor vehicle. And as a reminder, the offenses we have here are theft of a motor vehicle use without consent, and receiving stolen property. And their severity levels, the current severity levels are listed there in the table to the right. Here's where they all land on the standard grid. Motor vehicle theft, like in that previous table, has 1 severity level at 4. Motor vehicle use without consent is at 3, and then the receiving stolen property are in 3 different severity levels at this time. And so our the responses we received regarding these offenses were 6. The majority, the majority were interested in not re-ranking the offense. Just a slight majority at 6. We're interested in no re-ranking decision, while 5 were interested in re-ranking and consolidating. And all of those responses revolved around consolidating at severity level 4, on the grounds that the characteristics required to commit each offense were not sufficient enough to have different severity level rankings. So that the theft of a motor vehicle is a theft of a motor vehicle, regardless of the characteristics. So that's what we have for you on theft of a motor vehicle, and the comments are included in slides too for you all to review.
Any discussion on this one? It's not. Oh, I'm sorry. I missed 2. Okay, Commissioner Fraze and then Commissioner Castro.
Just repeat something I said in an earlier meeting that, and I'm trying to get my head back into all of these little subcategories. As between theft of a motor vehicle and use of a motor vehicle without consent, I think there's a clear difference. One is an intent to permanently deprive, and the other is usually temporary. So that's just a different harm there, or at least proven. And then the receiving stolen property. So what I'm not seeing in front of me is where we have how, if it's a motor vehicle, is it one of the, so we're given 3 severity levels, 2, 3, 4. If it's a motor vehicle, it doesn't matter on the dollar amount, as I recall. What is the severity level for receiving?
It does matter in the dollar amount. That's the thing. There's no special rule for motor vehicles with respect to receiving stolen property. That's the anomaly.
I might have misspoken. That's my understanding, that it's kind of like burglary. Burglary doesn't depend on the value of the house or what you intended to do in there. So it's 1 penalty for receiving a stolen car. Is that right? No.
It's by dollar value. So cars
it's
aren't
like-
special when it comes to receiving stolen property. But they are special when it comes to theft.
I understand that,
Yeah.
but with respect to receiving, I don't know why, I'm just not processing the answer.
There's 3 penalties depending on the amount of the vehicle
For
that you
receiving
receive. Yeah.
stolen property, including motor vehicle.
So it's the third penalty is just for firearms.
Yeah.
So for vehicles, it's either a 2 or a 3, depending on how much of a junker it is, basically. And
Okay, so.
then 4 if it's a
Comparison
firearm.
is motor vehicle receiving is either 2 or 3. So again, I guess I would say since receiving stolen property is knowing or have reason to know that it's stolen, the mens rea, the culpability proven is less. So therefore, I wouldn't put it up at 4. I would maybe only put it at 2, but 3 if it's a more valuable car. So that's why I voted no change.
Commissioner Castro?
I don't have anything to add. I was going to say the same thing that Commissioner Frey said at the first portion between motor vehicle theft and motor vehicle use, the permanency of motor vehicle theft. That's why I think it's appropriate to keep them separate. I mean, motor vehicle use was essentially the old joyriding. So I think they should have remained at 3 and 4.
Yeah, that's where I fell on that one too. It is a different mens rea really for both acts as well. All right, any other comments or discussion on this one? Okay, is that it?
That's all we have for you.
Yes. Well, that was the weirdest packet we've ever worked
Yes,
through.
I'd say, definitely.
Okay. Next we have committee updates. Do you want to do yours first?
Sure, yeah, the restructuring committee actually met and there's a will to try to get something done this year. So I don't know how realistic that is. We'd have to start coming up with a product pretty quickly. We do have a little bit of money left in the comprehensive review budget, so we could hire somebody who's, maybe more experienced at drafting legislation than I am, or drafting rules than I am at least giving it a look over. But we will try to have something for the commission's consideration if the chair is willing to put it on the agenda this fall, with the hope of presenting it to the 2027 legislature. So that would be the goal.
Great. The Hernandezing subcommittee has met a couple of times, and we have another meeting coming up in August. We've looked at a lot of data relating to the Hernandezing policy. And our next meeting will most likely focus on more data and a few potential, starting to look at policy to see if there's an appetite to change anything. We put a lot of ideas on the table, but we're at the really idea generation stage. We haven't coalesced around anything at this stage, but we'll continue to work on that. And so more to come if we have a proposal to bring forward this fall. That's the goal. And I think that's it for subcommittees, right? There's no other active
Two
subcommittees right now?
subcommittees.
Yep. Yeah. Any questions about either of those? Okay, then we'll move on to number 8, which is the task force on mandatory minimum sentences. Nate and I are both serving on that group, and we wanted to give this group a little preview of what's been going on there. Nate is the chair, so I'm gonna let him take over there, and I will provide a supporting role.
Thank you, Madam Chair. So the task force on mandatory minimum sentences was created last year, and it's met basically for a year. It expires next month, so it has one more meeting. But it made some significant decisions at the July meeting regarding mandatory minimums, recommendations to the legislature. I'm really going to focus on the first of these, though, because it implicates the Sentencing Guidelines Commission quite directly. And that is a proposal. Well, I mean, the task force has identified a problem with 6 and 9/11. I would say the fundamental problem is that 6 and 9/11, because it doesn't account for 6 and 9/11, of course, is the mandatory minimum statute that primarily penalizes the use of a dangerous weapon or the possession of a firearm while committing a variety of listed offenses. It also has penalties for merely possessing a firearm after having committed a crime of violence. And the sort of structural problem with 6 and 9/11, because it's a mandatory minimum, it provides a floor for penalties for these crimes. But in a sentencing guidelines regime, it doesn't really make a lot of sense, because people who have high criminal history scores or people who commit very serious crimes with firearms or other dangerous weapons essentially graduate from 6 and 9/11. So the people who are impacted by 6 and 9/11 are the people who commit the least serious offenses with and who have the lowest criminal histories. And it's kind of the opposite of what a rational penalty scheme ought to do. And it's not necessary to do that because we have sentencing guidelines. So what the task force is going to be recommending is that the legislature require the Sentencing Guidelines Commission to create a penalty enhancement scheme in the sentencing guidelines for committing violent felonies with firearms or while using dangerous weapons. There would be legislative guidance to the commission that would include 6 tiers of firearm involvement in violent crimes, from personal firearm possession or other dangerous weapon use at the lowest tier to firearm discharge at the highest tier. And the new penalty enhancement scheme would replace the existing mandatory minimum scheme for crimes committed on or after August 1st, 2029. So essentially, the commission, were the legislature to adopt the task force's at this point unanimous recommendation, subject to change based on final votes in August. But if the legislature would adopt that recommendation, then the commission would have its plate full, I would think, for the next year and a half, because the commission then would have to come up with, and honestly, it was basically too much for the task force to figure out all the details. But the task force believes that the commission has the expertise and resources to be able to hammer out all the details in this policy. So basically, the commission would have the mandate to come up with a replacement scheme for 6 and 9/11 that does account for criminal history and does account for offense severity, unlike the existing penalty scheme, and also provides more nuanced penalties for a wider spectrum of firearms or other dangerous weapon involvement. That I think if it were passed by the legislature would almost surely dominate the commission's agenda for a year and a half, essentially coming up with an extremely significant sentencing policy that would replace an extremely significant sentencing policy, 6 and 9/11. Any questions about that? So I think that's the main thing. There are some other recommendations also with quite a bit of support. But that's the one that most directly affects the commission.
So I mean, basically, we talked about on the task force that, you know, that as a, within the structure of the sentencing guidelines, we have multiple levers that we can pull to increase sentences based on those elements. So, you know, we can re-rank offenses to make them higher. We can flip a probation sentence to a commit as a policy. And we can also add time to an offense. We've done all three of those things in different settings. When we talked about it in the context of the task force, often we were looking at, you know, adding duration based on different firearms behavior. But we were really reticent to tie the hands of the commission. When knowing, as we were explaining to everybody else, knowing that we have all of those levers available to us, and like, if we take some actual time, we can figure out the best way to make it work. And this is also, well, anyway, either way, like, we have sentencing enhancements in the guidelines. We know how to do this, and we can do it in a way where, you know, everybody who commits that behavior with the varying levels of a firearm, like, it actually affects their presumptive sentence. Whereas today, that's just not happening with the way that 60911 is functioning, especially not for, as Director Wright said, not for people who are actually discharging the weapons in the commission of that crime. So anyway, we'll see what the legislature does with that. They may hate it, and they may not do anything with it, but that somehow we got somehow everyone in that room agreed to it, and we had a really wide, really good representation, I think, from across the board: law enforcement, prosecution, defense, sentencing. So I don't know how we got to agreement on that, but somehow we did. So we'll see if our plate is full next year or not. And I want to shout out to the comprehensive review, because we had some of the presentations that we saw here represented there on like the work that Dr. Laskarensky did on high departure rates for offenses with mandatory minimums. Since we had covered that in the comprehensive review, she represented it there. She had that stakeholder input on why those departures were happening. So that was a nice crossover between the two groups. Nice that we were able to share that work. And then, of course, our staff at the commission provided a lot of data along the way. So thanks to everybody over there for that. And that will also be showing up in the report. So that'll be good. All right. I guess we're down to the executive director's report.
Thank you, Madam Chair. We are taking only 2 commission members to ask, but I believe 3 commission members are coming on their own or through the agency or entity for which they work. So we should have a pretty good showing in August at the National Association of Sentencing Commission. The final session of the conference will be a presentation on the Minnesota Sentencing Guidelines Comprehensive Review and how that process went, and lessons that other sentencing commissions can learn. I was asked to speak a little bit about next year and sort of the process of, the implications of members on the Sentencing Guidelines Commission to some of the changes that are coming up next year. So I'm going to start by kind of dividing you up into 2 categories. So there are 2 types of members on the commission. There are appointees, which is most of you, and then 2 of you are designees, or, well, there are 2 ex officio members who are allowed to designate someone to serve in their place, and both both the Chief Justice and the Commissioner of Corrections, who are the ex officio members, have designated someone to serve in their places. So, but those seats belong to the Chief Justice and to the Commissioner of Corrections respectively. So for example, when the current Chief Justice steps down and Chief Justice Gaitis takes over, at that point, Chief Justice Gaitis will be the member of the Sentencing Guidelines Commission unless she immediately designates Justice Moore or someone else to replace to take her seat essentially. But the seat belongs to the Chief Justice. Likewise, the Commissioner of Corrections seat belongs to the Commissioner of Corrections. Why is that relevant? Because on January 5th, I believe, there will be a new governor, and very likely, if past is precedent, the new governor will come with a new cabinet, and so there will be a new Commissioner of Corrections. So that Commissioner of Corrections will be the member of the Sentencing Guidelines Commission unless that Commissioner of Corrections has immediately designated Chair Mitchell or someone else to serve in the place of the Commissioner of Corrections. So that's the status of the two designees. Now I'm going to shift gears and talk about the 11 appointees. So 11 appointees, you all, if you're an appointed member of the commission,
By the governor.
well, it could be two sources.
there's two, there's
So
more than
there's,
one.
yeah, there's two different, so I'm going to break that down next, but kind of, big categories first. So for the 11 appointees, you are all, you all serve until your successor is appointed. Okay, so, and everybody has 4-year terms and you serve, even if you're past your 4-year term. And by the way, all of the, well, I'll get to the governor's appointees in a minute, but once your term ends, you will, you continue to serve until your successor is appointed. So the appointees are not off the hook just because their 4-year term ends. Now, I'd like to break off the 11 appointees and take a look at the 9 gubernatorial appointees. So setting aside the 2 judicial branch appointees for the rest of the conversation. So those all by law, there's been a little bit of a change. And so by law, all the gubernatorial appointees are, their terms all expire on the first Monday of January 2027. So the same day that Governor 42 will take over, that's also the day that all the gubernatorial appointees terms expire. Subject to the asterisk that I just mentioned, which is you continue to serve until your successor is appointed. But what's important to know is that there's going to be a new staggered term policy that will apply to those 9 members. So Governor 42 will appoint 5 members to serve an additional term of 4 years, and an initial term of 4 years, and 4 members will serve an initial term of 2 years. So, and that'll be the terms going forward. So we'll have turnover of 4 or 5 members of the commission every 2 years. So what's going to happen there? Oh, potentially. I mean, obviously the governor could always reappoint, or the governor could not reappoint, in which case they'd stay on until their successor is qualified. But it is going to be a little bit different next year. So, implications for that basically are that things could and probably will be quite different starting on January 5th, 2027. So as far as the membership of the commission. So if this commission has something they really want to get done this year, my advice would be try to get it done before, including writing the report to the legislature. You try to get done, any red letter gotta do items this year, try to get them done before January 5th, because you just don't know what the commission's going to look like on or after January 5th, particularly since the chair is a designee position. So, I would say it's the seat she's in. I mean, I assume being chair, you continue to serve until a successor is appointed, but being a member, you don't. So,
I don't think it's possible.
yeah, no, right. You wouldn't be the chair if you weren't a member. So, yeah, I guess until Governor 42 appoints a chair or designates a chair, then I guess the vice chair would be acting chair until that time. And, you know, what I've seen in the past is, and maybe this goes without saying, but it takes, you know, the governor usually comes with a cabinet and including the Commissioner of Corrections, and then proceeds over time to appoint members to various boards and other groups. So sometimes it takes months before, particularly a new governor, appoints somebody. Now, having said that, governors are different. Some governors are much more efficient than others. Yeah, I would not try to be critical or anything. I'm just making an observation. Governor Walz was much more efficient about appointing people to groups like the commission than Governor Dayton was before. So it really depends on the governor. And but we do know that whoever the governor is going to be a new governor. So presumably that'll add some time to the mix. Any questions for me about any of that? Sort of the political realities of what's coming up here in a few months. And I apologize, I haven't gotten the 2027 meeting calendar out. I'll try to get that out pretty quickly, but you know, the formula is on the calendar that exists. It's a formula the commission adopted a few years ago. Obviously the commission can change the calendar for any given year, but it's nice to know that there is a formula.
I think, okay, so one thing that we did not talk about this before the meeting today, but one thing I have been thinking about is, you know, our November meeting is set up to potentially be a public hearing if we need one. So, you know, theoretically, between November and December, we could get our report done, whatever report we have.
Madam Chair, can I just make a
Yeah, but I'm worried about
clarification
your stuff.
Yeah, so the spacing is so that the December meeting could be a public hearing. So we need.
I thought it was the other way, that November is earlier.
Yeah, well, yeah,
So
there it is. Well, what we need is 6 weeks between the meeting before the public hearing and the public hearing. So they're currently
Oh, I
spaced
see what
out
you're
that way,
saying.
so that there's 6 weeks between the November meeting, which happens early in November, and then the December meeting, which happens 6 weeks later. And the reason we need the 6 weeks has to do with the 30-day requirement for publication in the state register.
Yeah. That's
And
right.
then the state register has deadlines that back us up 6 weeks. So,
We might want to, we'll have to talk, because I'm a little like, if you want to do your changes, I'm just trying to think through like when the commission would need to be able to see it.
yeah.
And, you know, if there's a way for us to do our final report meeting in December rather than January, I think that would be wise, just to be able to finish up the work that we're doing now. So we might want to look at that calendar.
Yeah, I mean, what would work on paper, which I'm not saying this would work in reality, would be having a meeting, you know, like between Christmas and New Year's. I realize that's like terrible timing, or I suppose you could do it. Yeah, I think,
If anyone wants to have a meeting between Christmas.
no, I know. But I mean, that would work on paper, you know, then you could keep consistency. Otherwise, you'd have to change. You'd have to shuffle some things around as far as other meetings. That would require the least movement, because we have, isn't it December 17th is our.
December 17th is our last meeting of the year. Yeah.
So, yeah, so that is 6 weeks after the November date.
Yeah, that's right. So that was, we originally were setting up the calendar, like the annual calendar is set up so that December can always be a public hearing if we need it. Yeah, that's what it was. I got that backwards in my head.
Right, which is, the idea is then that in January you could meet and finalize everything.
Yeah.
But that's problematic this year.
It is problematic this year.
Madam Chair? Yes. So does that mean if we're looking at those timelines and with some goals and hopes to do things essentially a month earlier, because we don't have January to do stuff like we normally otherwise would, does that mean we need to start tinkering with calendar now looking forward? Because I'm doing lawyer math and I shouldn't do that at a public meeting, but that's not a lot of time for stuff. And I'm just thinking about sort of what's percolating out there and with the holiday in there and that sort of thing. I feel like we're in end of July. So does that affect like the August, September, October dates that we currently have, if that's what we're looking to try to accomplish?
It could. But I think that we would have to talk about what possibilities are. Yeah. And we don't have a meeting in August.
Right.
Yeah.
No, and I think for the restructuring committee, I think we probably want to get something to the commission by October. Because of this second meeting rule or the second. Yeah, the rule where you have first reading rule there you go, where you have to have 2 meetings. You can't take action the first time you've heard something is the deal. So you'd want to take action in November and then, so you'd have to have it in October. I mean, there is a possibility to save a week. If you had an idea of what we were going to put in the public hearing, we could just put a very generic notice in the public hearing. And then we'd compress the timeline down to 5 weeks. We have done that before. I mean, it is supposed to say what, a brief description of the changes, but, we could be very brief on the description of the changes. Just make it, with the anticipation the commission is going to do something, we could put that in the public hearing notice, and then the details would be on the website. So that would allow us to have a meeting on the 10th. And then you could have your follow-up meeting on the 17th as currently scheduled. It's a little risky because you have to, we'd have to actually have the notice to the printer before the meeting actually happens.
Before the November meeting.
Before the November meeting, right? Yeah, we'd have to have our notice into the printer on the Tuesday before the meeting.
Yeah. Okay. Well, that seems workable. At the very least. Because at the very least, we want to have your changes in there. Your restructuring, right?
Yeah.
So we'd have to have a
yeah.
public hearing on that. Or
Right.
would we? Yeah.
Yeah, so so if you made a generic notice, by the time it got published, you'd have the specific information on the website. So essentially it would say, see the website basically for details. And,
Well, what generically, what do people think about that of adding a meeting on December 10th? So what we would end up doing is actually, we'd have a public hearing on December 10th, if, assuming that, especially that the changes that the other subcommittee are doing go through. So we'd have a public hearing on December 10th. And then we'd have our regularly scheduled meeting on the 17th. But we would also use that time to just approve our final report. We would vote on anything that happened in the public hearing. Write the report as if it happened.
Right.
And then we can make modifications there.
one thing I should have added in my subcommittee report or my committee report is that the committee is not considering making changes to the commentary or appendices at this time, just the black letter guidelines, with the idea being that the commission could next spring, possibly the lame duck commission that's waiting to be appointed, could work on the commentary and appendices, have a little bit more time. That doesn't necessarily have to be submitted to the legislature in advance because it's not really a policy change to the sentencing guidelines. And therefore, that could be worked on in the spring and then submitted to a public hearing in June or July, I should say. So It has the virtue of cutting down somewhat on the number of words that the commission needs to be able to digest and process this fall.
Does December 10th sound like a workable solution?
I was just gonna say, I think that other subcommittee is gonna have a lot of words to digest, which is gonna be, I mean, I think that's gonna be a big task along with getting the final report process done. It's just my personal opinion.
I agree. I'm not disagreeing. It's a lot, so we have to see where they shake out. I think all I'm saying is like, if they get to that stage, we should be ready to act on it. I like this idea of December 10th. It's like the least disruptive to our whole schedule. But it gives us the opportunity to do it if we have something that needs to go to a public hearing, and if we don't, then we cancel it.
Yep, right. We can always cancel it.
Okay. All right, well, that was fun. Updates. All right, is that it? I think that's it on our agenda for today.
We're going to just check to see if any members of the public would like to make a
Yeah,
statement.
that's what I was gonna move to. Go ahead. Sorry, make your announcement, please.
No, that's fine. So members of the public, if you would like to make a statement to the Sentencing Guidelines Commission at this time, you may, but I need you to raise your hands first so I can unmute you. And by raise your hands, I mean press the button on your WebEx app that has a little hand raise symbol by it. And I'll be happy to unmute you. Just waiting a beat to see if anybody raises their hands. Not seeing any. Let's see. Madam Chair, it looks like no members of the public are wishing to make a comment.
All right. All right, so that brings us to the end of our agenda. Just as a reminder, we don't have a meeting of the full commission in August, though I think both subcommittees might be meeting during that period of time. Several people are going to NASC. And our next meeting is September 10th, Thursday, September 10th. So enjoy the rest of summer. And unless there's an objection, I will adjourn the meeting. Meeting's adjourned. Thank you.
And it's not 5 o'clock. That's what I said on the